Hey, everybody. Happy True Crime Friday. Welcome. I'm your host, Lori Hellis. I'm a retired criminal attorney and the author of this book about the Vallow Daybell case. Welcome. We have a lot to talk about tonight. For those of you who have been redirected over from excited utterances live earlier, we talked fairly in depth about the Corey Richens case because the Richens trial is coming up starting on the 23rd of February. They were able to pick a jury in lightning at lightning speed, and so the jury has been seated, and now we are waiting for trial to start. It's a little unusual to have this sort of a gap before trial starts. However, that was due mostly to the fact that sorry, I'm looking at my other screen because I had some other things I wanted to pull up. I'm a little out of sync because I had to rush to get back on here after uh, being with Hella. So it was a little bit unusual for them to be able to pick a jury so quickly. Usually that takes more time. And they left a lot of time because, of course, this case has been highly publicized, and there was a great deal of consternation about whether or not they were going to be able to seat a jury. In fact, Corey Richen's team renewed their motion for change of venue. Sorry, I'm trying to do too many things at once here. Um, they renewed their motion for a change of venue really just before they started doing jury selection. The court once again denied that, saying that that he believed that they could find a jury. And in fact, lo and behold, they did seat a jury in record time, in less than 3 days, about 2.5 days. They were able to seat the jury that will hear the case. So, darn it, somehow I've lost my screen. Um, Gosh, I feel like I'm pulling a Trisha. I want to dee 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 dee. Well, I try and get stuff back together, but um, so bear with me because I am going to have to do a little bit of recalling. So they were able to seat that jury in fairly record time, which was surprising for everyone because I think everyone thought that it was going to be a lengthy jury selection, as we've seen in other cases. Um, but they seemed to be able to seat a jury that they felt was going to be not going to be biased pretty quickly. So what that meant was the time that the judge had left available for jury selection now was unfilled. Well, to move the trial up would have meant that they would have to rewrite subpoenas and change people's schedules, and out of town people would have to rearrange travel, all those things. So the judge decided that they would go forward with opening statements on the 23rd as planned. Now, I can't lie, if I were the defense attorney, I'd be doing the happy dance because you have more opportunity at this point, more time, to get ready for the, to get ready for the trial. So, I had a couple of things which I had on screens all prepared for you, all queued up, and somehow in all of the shuffling around and getting online with Hella, I managed to lose them. So I'm going to do my best to pull them up because there are things that I do want to talk about with you other than the Richens case. Now, there are a few things that I want to talk to you about regarding the Richens case. Um, but there were a couple of other things that I wanted to show you as well. So let me just very quickly pull up the things that I was thinking about and see if I can find those things. I hate doing this, but I had a specific short that I wanted to show you that had to do with a different case, and it was worth watching. And uh, of course, I had it all queued up, and where did it go? Um, I will say that I noticed Melanie Little has been following this case, the case I'm talking about, closely. I'll keep trying to find it, but in the meantime, um, I will move on with the other things that I wanted to talk about. Um, because there are other things to talk about. So I have one of those queued up for you, and we'll talk about that when we're done with Richens. But I did want to talk about Richens because we're getting ready for trial. One of the things that the Richens case, one of the biggest issues surrounding the Richens case has to do with something called the walk the dog letter. So, in the Richens case, after Corey Richens was in custody, they tossed her. Sorry about that. I'm hitting too many buttons. The jail staff tossed her jail cell. Not at all unusual. Happens all the time. They're working hard to um, they're working hard to make sure that contraband isn't introduced the um, into the jail. Everything from her infamous white strips to all sorts of other of other things. So there's always a concern about getting not having contraband in the jail. For that reason, jail staff often um, does no notice um, cell inspection. So they toss the defendant's cell. So in Corey Richen's case, they went through Corey's cell and they found an envelope. And I didn't pull up all of these pictures and things to show you, but there actually is a dispute about where this was found. They found what appeared to be a letter. Across the top of the letter, it had the words walk the dog, which so it's become known as the walk the dog letter. So, in the process of that, the jail staff says they found that letter in a book sort of ironically, a study guide for the LSAT, which is the entrance exam to get into law school. And there are study books that include practice tests and test strategies, those sorts of things. So they claim that they found this letter in this book. Corey claims that she had a manila envelope that had her lawyer's name on the front and attorney privilege on it. And it had quite a few papers in it. And she claims that the jail staff got into that envelope, took out that single page, and left the rest of the paperwork in the envelope. Later, Corey claims that this was pages of a novel that she was writing, and that she gave it to her lawyer. Now, why that would qualify as attorney privilege, well, frankly, it wouldn't. Um, so there's a dispute as to whether or not it was even identified as attorney privileged information. But they claim that it was in that envelope and that the jail staff took it out. So I did a little bit of legal research and I looked up the controlling case in Utah on attorney-client privilege. In this particular case, they talk both about attorney-client privilege and about attorney work product because they sometimes go hand in hand. So attorney work product is anything that I, as a lawyer, um, it's sort of like intellectual property. It's my thoughts, it's my notes, it's my research, it's my legal theories, um, a- anything that is created by me in furtherance of the case. So, in order to be considered work product, it has to have been. It has to be a document or a tangible thing. Could be a recording or a video prepared in anticipation of litigation or trial by another party or by that party's representative, their lawyer. So, and that information is protected. The other side can't get my notes and my legal theory. If I sit down and I look at the statute and I figure out how the facts meet the statute or don't meet the statute, and I make notes about things like evidence rulings, whether or not this particular piece of evidence can be gotten in at trial, and what the objection might be, and what the the rule might be that I can get it in under. That is all protected. It does not have to be disclosed either to the other side or even to the client. Um, if later the client says, I want a complete copy of my whole file, the lawyer does not have to turn over their work product. That is the product of their own, it's their own thinking. And that property is considered to be the lawyer's prerogative to keep private. So let's talk a little bit about why there is an attorney-client privilege in general. So, in general, what we say is that communication between a lawyer and their client about their case, that's important, is privileged. What that means is that the US Supreme Court has said that the purpose of the privilege is to encourage clients to make full disclosure to their lawyers. And so the privilege has the effect of withholding what could be relevant information from the fact finder, from the jury or the judge, because um, it is designed to try and make sure that clients can be frank with their lawyers. So the judge in the Richens case makes the point that there are times that the First Amendment may run afoul of this. But the important thing to note in this case is that simply marking something as attorney work product or as privileged information is not what makes it privileged. Because if you take a piece of paper that has absolutely nothing to do with the case that you're preparing for and you write attorney privileged on it, that piece of paper is not privileged. Um, what the law says is that the document that you cannot protect documents, let me get to the right page here. You cannot protect the documents simply by scrawling attorney-client privilege on them. You can't. The mere existence of an attorney-client relationship does not make all communications between the lawyer and the client confidential. Only the stuff that is directly related to the case would be confidential. Further, you can't merely labeling a document protected by either the work product or the attorney-client privilege does not make the document privileged. Any document for which protection from discovery is claimed must be independently analyzed to determine if the privilege actually applies. So, when all these documents were disclosed, the next thing that happened was the sheriff's deputies, the jail folks, found this walk the dog letter. They then turned it over to the prosecutor. The prosecutor later, Corey Richens took that envelope that had her lawyer's name on it and said attorney privilege, and it was full of pages purportedly of a possible novel that she was writing, and passed those off to her lawyer. Well, so we have to look at those and say, are they protected? Two things happened. First of all, Corey gave those to her lawyer. Second, the the jail staff gave the letter, law enforcement gave the letter, the walk the dog letter to the prosecution. The prosecution believed that it was an attempt to influence witnesses because it was a letter apparently directed to Corey's mother, directing her to talk to her brother about telling law enforcement that Eric had been bringing drugs back from Mexico and that Eric was using drugs beyond the THC gummies that everybody knew that he used. So the prosecution immediately filed a request with the court, a motion with the court, saying they wanted Corey Richen's contact with her mother and her brother suspended. And they went through the reasons why, saying that the court needed to stop the contact between them to stop any further witness tampering, implying that there had been witness tampering. And they attached the walk the dog letter to that motion, and it was filed on the public docket. Now, this judge has been kind of quick to seal things, but this motion was filed publicly. So it immediately made it into the public sphere, and the media had it. And suddenly everyone was concerned that Corey Richens was attempting to tamper with witnesses. So the defense then got very huffy about the whole thing and filed a very a really, I mean, you want a perfect example of a beautiful and well-researched and well-written motion. That motion is really one that you can hold up and say, this is what a good motion should look like. Now, we can argue about whether or not there was legal underpinning for it or whether it was justified, but they were hot under the collar because there was a gag order. Now, as we've seen in other cases, oftentimes what happens is the prosecution tells everybody all about their case, all about their theory of the case, and then asks for a gag order. So it's really the defense that gets gagged. But in this case, the defense filed a kind of a comprehensive motion, what some jurisdictions might call an omnibus motion. And it asked, among other things, it asked for the case against Corey to be dismissed completely because of the violation um, of her due process rights by publishing the letter and intimating that she was tampering with witnesses. It was creating bias in the jury pool and that she would not be able to get a fair trial, so her due process rights had been violated. So the next thing that they alleged was that the prosecutors had been unethical in the way that they had written their motion and the fact that they had made that public, and they wanted the entire prosecution team to be disqualified. And the third thing was they wanted to suppress the walk the dog letter, and they wanted the prosecution held in contempt for having violated the gag order. So, um, while the motion expressed a fair amount of outrage, it wasn't real hyperbolic like we see in some filings. If if any of you had the misfortune to read some of the early motions in the Lori Vallow case that were filed by Mark Means, talk about hyperbole. But this was a really excellent motion. Now, the judge heard the motion, there was a hearing, and the judge made some rulings about it, and they didn't all go very well for Corey Richens and her lawyer. The judge found that the claims that Corey Richens couldn't get a fair trial because the prosecution had tainted the jury pool by releasing the walk the dog letter. The judge said that there wasn't, the legal standard was that there was no substantial cause for dismissal. So he believed that it was still possible for them to seat an unbiased jury, which ironically they did really fast. So that seems to, the speed at which they were able to seat a jury sort of belies the claim that the jury pool had been tainted by so much pretrial publicity. So the judge also said that he did not find that the prosecution had tainted the jury pool, and that what they had done was within the bounds of permissible advocacy. So it's important to remember that in a trial, neither side can comment on the evidence. When you're presenting at trial, you're basically presenting the evidence to the jury. Now, cross-examination is all about poking holes in that evidence, about calling it into question. But you as a lawyer cannot comment on the evidence. And oftentimes it's considered a form of vouching. So you can't, as the lawyer, vouch for the evidence. You have to put witnesses on who vouch, who can say, yes, that information was accurate, or no, that information wasn't accurate. In order to prove that, you can't vouch for the evidence. So the judge found that even though they had said in their motion, we want them not to have any contact so that there can be no further witness tampering, the judge found that that was permissible advocacy and not unethical conduct. So the judge denied the motion to dismiss, denied the motion to um, disqualify the prosecutors, um, took up the issue of the walk the dog letter in a separate hearing about its admissibility, and but the judge also declined to limit the contact that Corey Richens could have with her family. Now, those of you who've watched some of the pretrial motions, this is the judge that has the really nice radio voice, and he has, from the very beginning, really, I think, been really even-handed. He has definitely, he's very prepared. He's very on top of things. He rules from the bench, which is always nice. And I think that he uh, did a good job of sort of weighing the arguments on both sides and making a decision that I think was fair. Now, we have to get back to the envelope that Corey Richens gave her attorney, Sky Lazaro. So she gave the lawyer this envelope. Nobody but Sky knew what was in it. She didn't know what was in it when she took it from Corey in the jail. It turned out that at least some of it was this purported manuscript of this fiction thing that she was writing. So remember, Corey Richens claims that Eric Richens used to go to Mexico with friends or brothers, or I don't know, used to take a guy trip to Mexico. And she claims that Eric Richens was much more involved in drugs than anybody knew. And so she claims that Eric brought the fentanyl back from Mexico and that he took the fentanyl, that she didn't give it to him. So the curious part about that is there was no fentanyl recovered in the house. So it's hard to figure out how somebody could take fentanyl and there wouldn't be any in the house. But that is her claim. So this novel that she was writing, according to her, because she has some text communication with her brother where she explains all this. She wrote her story as it happened up to her detention hearing. And then after that, she took off thinking to herself, well, what would happen if I did get bail? And what would happen? So suddenly Corey Richens is no longer Corey Richens. She's a character in a novel. So the character in the novel in her story gets out on bond and she promptly absconds off of her bond and goes to Mexico to find the real killers. Okay. She's going to go to Mexico and find the person who gave fentanyl to the husband character in the book. You have to wonder a little bit if this was sort of fantasy on her part. One of the things in the novel is the fact that her father has passed away fairly recently within the 2 or 3 years before she's arrested. And in her story, her father, the character's father, goes with her to Mexico to try and find the real killers. So the next thing that happens is the prosecution says, you have an obligation to disclose all that stuff. Sky Lazaro is caught in the middle of having to say, well, it says it's attorney-client, and I'm going to claim that this is protected by attorney-client privilege. And the prosecution says, no way, we wanted to have it reviewed by a third party. In legal circles, that third party bears the sort of unlikely name or awkward name. They're called a taint team. Means whether or not the attorney-client privilege material is tainted by its release. So the third party is appointed to go through the materials and determine whether or not there's actual attorney-client privileged material that is communication between an attorney and their client about their litigation within that envelope. So they review it. They recommend, and the judge redacts a few pages of it, but essentially it's going to come in. The material that is actually attorney-client material will not come in. Now, the next question is, what do we do with the walk the dog letter? Now, Corey Richens claims that it is covered by attorney-client privilege because it was in an envelope marked attorney-client privilege at the time that it was seized. The jail staff say they seized it out of a book, an LSAT test book. Somehow, at least to me, that seems a little bit more likely because of the level of specificity. They didn't just say they found it in a book. They didn't just say they found it laying around loose in her bed. They were very specific about saying, we found it folded in half in this book on LSAT testing. The letter itself says essentially to the person it's directed at, I think we all presume it's her mother, that she wants to tell her brother what to tell law enforcement about Eric bringing back drugs from Mexico, and that Eric's drug habit was a lot worse than anyone knew. We don't know whether that's true or not. All the indications are, and in the communication that we've seen so far, the only references are to the fact that Eric Richens used THC gummies. There's some suggestion he used them to sleep, and there's some complaints between he and Corey Richens in text messages about the fact that he would come home, take a gummy, and check out, and leave her to take care of the kids and do all the household stuff. And there was sort of a lot of friction around that. So there isn't any indication prior to his death that drugs were a bigger problem for him. The judge ultimately ruled that the walk the dog letter can come in, but there are several sentences that should be redacted that at least intimate that they might be attorney-client privilege. At one point in the letter, she says something along the lines of Sky said. Well, Sky Lazaro is her lawyer. So she's repeating some sort of legal advice she got from her lawyer. I question whether or not that could be protected. In general, once you disclose information to a third party, it is no longer protected under attorney-client privilege. So, ironically, if the letter had been in that envelope and had been given to Sky Lazaro, Sky Lazaro would have had an absolute obligation to keep that confidential because it was something her client had given to her. And it appeared to have some sort of indication of consciousness of guilt. But the fact that Sky Lazaro never got it because the letter was intercepted before she got it and was never delivered to its ultimate, either to Sky or to the ultimate addressee. The law enforcement got it first and they were able to use it. So the walk the dog letter comes in. The imaginary novel is going to come in. There are portions of it, some pages of it that are not going to come in, but most of it is going to come in. And the jury is going to have to decide what to do about that. The jury is going to have to decide what weight to give that. What does that mean? Does it mean that Eric Richens had a drug problem that no one knew about? Or what else can they infer from that information? So we're going to wait to see what else the defense has. But it's clear that the defense theory is going to be that Eric Richens took the drugs himself and that Corey didn't have anything to do with it. Now, remember, this is a circumstantial case, so the jury is going to have to draw inferences from the circumstances surrounding what happened. We've talked before about the fact that a circumstantial case is sort of like a chain. Now, the prosecution doesn't have to have every link because the jury can make inferences if the link is not too attenuated, if the blank space is not too far, the jury can make that link. Now, we've talked before about circumstantial evidence, and I've described it this way. Picture that you have a jigsaw puzzle with 500 pieces. And when you look at the picture on the outside, there's a horse, there's a park bench, there's several other things that are brown. And you start piecing things together and you realize that this blob over here looks like it's park bench shaped, but it's not fully formed in, so you can't quite for sure tell that that's the park bench. And over here, you've got this brown area, but it's not fully filled in, but it looks suspiciously like the outline of a horse. You can infer that that's a horse. So, in the same way, you don't have to have every jigsaw puzzle piece in order to figure out that that's the park bench. You don't necessarily have to have every connected piece of circumstantial evidence to be able to say, I think the evidence shows. So, now there are two different cases here because the initial case was the murder case. And in that initial murder case, because they were making sure that if they were looking at aggravating factors and moving toward the death penalty, that they had enough to charge her. They brought in some of the financial crimes. So there, in addition to the murder, there are a couple of charges having to do with financial crimes because Corey Richens was um, deeply in debt trying to flip houses. And the state believes that the motivation was financial, that she believed that she was going to get Eric Richen's life insurance and all of his interest in his business. And in fact, Eric Richens had changed his will and his succession in his corporation to direct everything to one of his sisters. So she got very little when he died. So the state is saying that they believe that the motivation was financial, and that is an aggravating factor, particularly if they were going to seek the death penalty. Now, prosecutors make those decisions early in the case. So when the prosecutors are making charging decisions, they're going to do their best to make sure that everything is on the table. Later down the line, they decided that they weren't going to seek the death penalty. And not surprising, I think seeking the death penalty for women is rare. And in states like Idaho and Utah, I think it's even less common. That's why when Lori Vallow was charged and they sought the death penalty, that it was so shocking. Um, so the prosecutors threw in those financial crimes. However, a lot more financial malfeasance has turned up involving Corey Richens. A lot of fraud, a lot of mortgage fraud, a lot of other things. Think Alec Murdoch has come up, and so they have now filed a separate financial crimes uh, case against Corey Richens, and the financial crimes that are involved in the current case are only going to be used as aggravators as they go forward. Their primary goal is not to prove that the fraud and all of that. Their primary goal is to prove the murder. So, um, so right now, jury selection is done. Opening statements are going to start on the 23rd. I'm going to be watching it carefully and closely. Um, and I don't know if in the future we may see me live streaming trials. I think it's possible, but I don't intend for it to happen on the Richens case. But I will be following. I did want to talk a little bit about Corey Richens' change of lawyers. Now, she had Sky Lazaro, and I'm here to tell you, if you have seen Sky Lazaro in court, she is a very attractive woman. She's tall, she's slender, she's very beautifully groomed, always impeccably dressed. But beyond that, she is really brilliant. She is a really good lawyer. And I think that's illustrated by that fabulous motion that she filed. I mean, she's really on top of her game. So when Corey Richens initially was under suspicion and arrested, she retained Sky Lazaro. But let's remember that that was before all of the civil suits were filed about Eric Richens' estate and about the family filing wrongful death suit. So Corey did at that point have access to some money. That money now is tied up in Eric's estate. So I think it was a combination of things, but Sky Lazaro could very well have notified the state that her client was out of money and could very well have been asked to be appointed to Corey Richens' case. That does happen. And I believe that it was possible that she could have filed um, a notice that her client was indigent and no longer had the funds to pay her and asked the state to appoint her as counsel. Now, the state, there's no state that pays as much as a retained lawyer would get, but she would have been able to continue on the case. I think that is possible. And generally, when we see an a lawyer withdraw because it's a money issue, we see the lawyer pretty transparent about that with the court. We saw that in the Vallow case where John Pryor went to the judge and said, he's out of money and I'm essentially doing this for free. Um, so in this case, I believe what happened in the Vallow case that was complicated was John Pryor would have could have asked the court to appoint him, but he was Chad Daybell's lawyer. The problem was he was not death penalty certified by the state. And so that was the problem, the roadblock to him being appointed. So in this case, I don't think there were any roadblocks to Sky Lazaro being appointed, and I think that was possible. So I think that it would be unusual for a lawyer to very abruptly ask to withdraw from a case and not be more transparent except in this circumstance. If a lawyer, now remember, a lawyer has an ethical obligation. They owe a duty of truth to the tribunal. So they have an absolute duty to the court not to suborn perjury and not to ever, ever allow or encourage anyone to lie to the court. On the other side, they have an absolute duty to zealously advocate for their client and to keep their client's confidences. Okay. So sometimes what happens is the lawyer learns that the client intends to be untruthful with the court in some way. And then the lawyer is caught in this conflict between their obligation to truth telling to the tribunal and their obligation to keep their client confidences. So they can't go to the judge and say, "Judge, I need to withdraw because my client is going to come up there and lie a blue streak." But courts understand that in that instance, and it is well settled, it is in the ABA ethical guidelines and every state's model rules, okay? In ev in any at any time that a lawyer believes that they're in that conflicted position, what they do is they go to the court and they say, "Judge, I am currently in a position where I must withdraw. It is mandatory. So every ethical guideline says if you find yourself in that conflict where you're caught between your obligation to be truthful to the court and your obligation to keep your client's confidences, you must withdraw. It is not optional. You can't waive it. It is a mandatory withdrawal situation. So every lawyer is taught in baby lawyer school um, that the way that you tell the court that that is the issue is you say to the court, I am in a situation where I must withdraw. And if the court asks you any further information, you have to say to the court, Judge, I respectfully cannot answer your question because it would require me to violate my client's confidences. And so the judge understands that that is code. That is how a lawyer telegraphs to the judge, I need to get the hell out of this case now. Um, and everybody sort of says, la, 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 I can't hear you. Yes, you can be released and I'll appoint new counsel. Because the new counsel may not have the same problem because the client may not take the same direction with the new lawyer. So the other thing that I'm thinking is that Sky Lazzaro's firm was also representing Corey in the civil cases, the wrongful death and all the nonsense about the estate. So somebody from Sky Lazzaro's office was also representing Corey in those cases. And it happened that shortly after there was some sort of a hearing in the civil case, Sky Lazzaro said, something has come up in the civil case that leads me into this mandatory withdrawal position. Nobody knows what that is, and Sky Lazzaro is not gonna tell anybody because she has an obligation to keep her clients' confidences. But she also has an obligation to withdraw before any sort of a lie can be told to the court. And so she withdrew pretty abruptly. She cited in her motion irreconcilable and non-waivable ethical conflict. I tell you what that means to me. It means that Corey was going down a road that Sky Lazzaro knew was not true. We don't know how she knew it wasn't true, but we know that that it was after Corey's preliminary hearing and after hearings in the civil case. As a lawyer, that sends up huge red flags for me. And the first thing I think is, ooh, that really that really indicates something about Corey's credibility. Um, I could be wrong because we haven't seen these documents, but I can tell you what that means when I used to file those kind of motions. So the judge talked a lot about in that same hearing where he talked about the dismissal. He talked a lot about the coverage um, and the media coverage, and he made a really interesting comment. He said there was no question that the media coverage was inordinate, that there was so much of it. He said the media coverage was so large, it isn't in the interest of justice. So he clearly said that the pretrial publicity absolutely impacted Corey Richen's ability to get a fair trial. That all of that wasn't in the interest of justice. But he said The First Amendment works the way it works. And so he was forced to balance First Amendment issues, First Amendment rights versus Corey Richen's right to a fair trial. This is the judge who did decide to allow the case to be streamed because he felt that the First Amendment rights were such that even if it could impact Corey Richen's right to a fair trial, that the First Amendment trumped that. But he did say, going forward, it will require careful and lengthy voir dire. Voir dire is, they pronounce it 100 different ways. I learned to pronounce it voir dire. Some say voir dire, especially in the South. Anyway, and it proved that with careful voir dire, they were able to seat a jury, and a lot faster than anybody ever expected that they were going to. He also pointed out that the publicity was occurring long before the walk the dog letter. So the walk the dog letter was just sort of the icing on top of the cupcake. So we're going to go forward, and we're going to be listening carefully when opening statements start on the 23rd. Now, I have a lot of other, not a lot, a few. I think we're going to keep our stream fairly short tonight since I spent 2 hours on with Hella and Dolly earlier, and I'm kind of pooped. But there are a few things that I wanted to talk about, and there are a couple things just housekeeping wise that I wanted to mention. First of all, don't forget, this is not legal advice. If you need legal advice, you need to consult an attorney in your jurisdiction. I also wanted to remind everyone that if you have purchased a copy of Children of Darkness and Light and you would like a signed book plate for your book, you can drop me an email, please. Don't put it in the comments if you don't want your address out. Drop me an email and I will mail you a book plate. I'm happy to do that and appreciative if you have purchased the book. One thing I wanted to mention tonight, and maybe for you all on the East Coast or in the Midwest, this is kind of, maybe it's not as, it doesn't weigh as heavily on you. But this evening, yesterday, we have had a very mild winter in the West. I know you guys in the East have been slammed at different times, but we in the West have had a really mild winter. And what that means is that we don't have the usual base of snow, the snow accumulation in the mountains that we usually get. It's going to impact our water supply this summer. It's not a good thing that we don't get a snowpack. But unfortunately, just recently, we had a huge dump of snow in the Cascades, in the Sierras, all along that spine of mountains that runs along the West Coast. And what happens when you have a huge dump of snow and you have some unpredictable warming, cooling sorts of temperatures that often happen in the spring, where you have a warm day followed by another snowfall, you get the conditions to be perfect for avalanche. Now, those of you who don't live near mountains, probably it's not a big deal. But in the West, where we live among the mountains, avalanche danger is really on the top of your mind in the spring. And the conditions have been perfect to cause avalanches. There was an avalanche at Tahoe, and 8 backcountry skiers it appears, were killed in the avalanche. They had recovered all but one of them, and they were still working on that earlier today when I read the news. I live in Bend, which is a ski town. There is a ski mountain 20 minutes away from downtown Bend. My husband spent many, many years on the local search and rescue team with the sheriff's office, and I can tell you that he responded, the search and rescue teams responded more than once to avalanches, and it's tragic, and it's avoidable if you're not in the backcountry. So I just would encourage everybody, if you are a spiritual person, please send up a prayer for the families of those folks. It's very difficult because they're usually young, healthy, adventurous types that are out backcountry skiing. And it's really tragic. So lift those up in your prayers. The other family that we need to be lifting up in our prayers is Savannah Guthrie's family. And I haven't covered this a great deal, but there was something I wanted to talk about um, today. And I don't want to get overly political. You know, we try not to be overly political, but I think that we cannot. There's been a lot of talk about friction between the FBI and the local police. And it is somewhat unusual. Now, I'm not gonna tell you that there aren't power struggles. Um, I mean, the sort of textbook, um, the FBI showing up on the scene in their aviator glasses like something out of Die Hard and saying, I'm the FBI, I'm in charge now." Um, I think that there's at least some truth to that. And I think sometimes there are power struggles. The FBI does not have exclusive jurisdiction to investigate a case unless there is a federal issue. Otherwise, they are invited in to help with a case by the local police. And there's no question that the FBI has many, many more resources at their disposal than anything that the local police could have. Um, just in terms of the technology they can bring to bear. Um, so, I mean, technology like geofencing, like being able to pick a perimeter and just and go back and pull calls off any cell phone calls that were made within that perimeter. Um, all of those things are a lot of forensic technology. They really have state of the art lab, but there has been an awful lot of questions about the FBI and about this. I'm trying to be as frank and as non political as I can. There have been many questions about the, the way the FBI has been running since this administration took over. And it is a federal law enforcement agency, and it is impacted by the executive branch. And so I think it's not surprising that local officials might be a little more cautious than they would have otherwise been in inviting the FBI in and turning the investigation over to them. So there has been a lot of sort of grumbling about, well, the FBI ought to be in charge. And public grumbling. And I can completely understand why the local government would say, we need to proceed with caution. We need to be sure that we're serving our constituency, our public, and our local citizens, including Nancy Guthrie, in the very best way we can. So we need to be certain that we're operating this investigation with as much integrity and as much um, forcefulness as we can. And I yeah, Hellis says not the FBI. I know that's a every time I hear the word the FBI, I hear Emily D. Baker's "The FBI" that she plays. So, uh, I just think that it is perhaps not as surprising as it would otherwise be because there have been concerns raised by the public about the FBI under the current administration. So I am trying really hard. I'm not passing judgment, but I'm just saying that what we need to do is we need to be aware of that and that that may very well be a factor in what we're hearing is this contention going on between the FBI and the local police because it's surprising that the FBI and local police would be rubbing up against each other and not working together. So I just throw that out there as a possibility. Now, we've also heard that this sheriff is a real egotistical butt and that he's one of those macho guys who it's my way or the highway. And that can be part of it too. I can't discount that because I'm not there. But I do think that it's worth at least noodling over to think that there may be some other factors that contribute to maybe the local police, the local authorities being a little bit more cautious about how they're moving forward with the FBI. Um, I I continue to be very concerned with the irresponsibility of the media and particularly online creators in some of the things that they are espousing, involved with this case. Um, I mean, just a few days ago, SWAT went out on a person of interest. They detained 3 people, they questioned them and released them, and nothing more has been said about those 3 people. But that same night, in a completely unrelated case, police made a traffic stop, and the person who they stopped unalived themselves. We don't know why. We don't I mean, this does happen occasionally if someone believes that they're being caught for a crime that they don't wanna face, and it does occur. But all of the online folks jumped to the conclusion that this person they conflated it, and they jumped to the conclusion that this person over here was somehow related to Nancy Guthrie. And it spread like wildfire because, of course, if there was a Nancy Guthrie related traffic stop and the person jumped out of the car and unalived themselves, that would be significant. But it wasn't true. No, nor was it true when some pretty reliable sources like Ashley Banfield came out and said the son-in-law is the chief suspect. That wasn't even remotely true, not as far as anyone knows. Now now law enforcement has said that they have cleared the family essentially. So it was never true, but his reputation may be ruined forever, um, even if it's proven that he had absolutely nothing to do with that. So I would just encourage everyone to sort of believe me, I understand. I have a 92-year-old mother. I understand that an 84-year-old woman disappears from her home. There's blood in the house. I mean, everyone who has a bit of a heart is going to be frantic for finding Nancy Guthrie. Um, but we can't lose sight of the fact that we can't jump to the conclusions. It isn't gonna bring her home. Jumping to the conclusion that somehow her son-in-law is involved is not gonna bring Nancy Guthrie home. Nor is jumping to the conclusion that a traffic stop is somehow involved with the case. That's not gonna bring her home either. And I get that it's hard to sit back, take a beat, and say, "We've gotta let law enforcement do their work." And I understand the clock is ticking, and she is not a young person, and she had a pacemaker, and she needs medication, and we don't know what her condition is. But we're not going to get a resolution any faster by putting out irresponsible information, and may very well impede the investigation by sending the law enforcement off on wild goose chases to chase down leads because people are screaming, "My God, they're accusing me of something I didn't do." So, um, let's all keep the Guthrie family and Nancy in our prayers, and let's take a breath and let law enforcement do their job. Um, and that includes all of those reporters and creators who are camped out around Nancy Guthrie's house. I'm sorry, but Brian Enton needs to take a nap. Um, I I think I think it was he followed the SWAT teams and was so close behind them that he ended up inside the perimeter and they had to shoo him out later. I think that's really irresponsible and dangerous. Dangerous for his crew, dangerous for him. And so, Brian, take a nap. Nobody's going to fault you for taking a break. Now, I want to move on to the Dee Warner case. We've been following Dee Warner since she was missing. She was missing for several years. Before her body was found. Her children have always known that something nefarious happened to her and very much believe that Dale Warner, her husband, was responsible. Now, Dee Warner was married. I think she had 4 children with her first marriage, was divorced, married Dale Warner. They had 1 child together who is like young teen, maybe. Um, Dale's Dee's family and friends have been testifying. Now they're getting law enforcement on the stand to talk about some of the more technical things. But this was a family that essentially lived on a big family compound. They had a farm. Um, they had heavy equipment. They had a farming and a trucking business. And so there was a lot of heavy equipment around, and the families all lived sort of either on the property or within close proximity to Dee and Dale. Many people testified that Dale and Dee's marriage was very conflicted, that they fought a lot, that Dee had talked about divorcing him before. It was a very volatile relationship, and so Dale, I'm sort of curious, we haven't heard the defense yet, what it is that Dale Warner is how he is going to spin this when the defense takes over. I'm trying to figure out what the story is going to be. The only defense seems to be the Saudi defense. Some other dude did it, right? But if so, who? And if that other dude did it, how did her body wind up welded into a a fertilizer tank? So, my understanding from some of the testimony now, I have not listened to every minute of every of the testimony, but my understanding is from one of the people that worked on the farm that they would mix fertilizer, they would mix liquid fertilizer, store it in these big tanks, and then they would use it to spray the crops. So Dee's body was found in one of these big storage tanks, huge storage tanks. And the tank had been welded closed, and then the weld had been painted over to make it appear that to disguise it. And Dee's body was found in one of those tanks. So I'm sort of at a loss as to what the defense is going to be. We haven't heard a lot about the defense. I mean, I suppose that they could allege that her lover did it, or they could arrest. But apparently, she was having an affair. It was at least suggested during trial that both of them had had relationships outside their marriage. But it's sort of mystifying to me what defense they're going to put on, other than to say he didn't do it, somebody else must have. Because there's a lot of circumstantial evidence that points towards Dale Warner. So it will be fascinating to see how the defense is going to spin it. So, and then I have a couple of things that I wanted to talk about today. And one of them, I don't know if this is anything you're going to see on anybody else's channel, but I wanted to talk about it here. So today, I'm going to share my screen. And I'm going to move myself out of the way here. This is a press conference that happened today. Now, this woman in the middle, this is Gloria Allred. She's a California attorney, and she has been in the news so much over the years, representing in typically victims. So she represented in the Lacey Peterson case, she represented Scott Peterson's mistress girlfriend. And over the years, she has been a big advocate for crime victims, does a lot of I think things like wrongful death and sort of advocating for victims. So this is an absolutely fascinating press conference, and it's not really a criminal case yet. So let's just take a quick
listen. My left is Crystal Hefner, and to my right is my associate,
I'm going to speed this up a little bit.
Now a partner in our law firm, Allred, Rimrock & Goldberg, and her name is Olivia Fleshing.
So let me just set the stage here. This woman, I don't know if you can see my cursor, but this woman all the way on the right in the white, this is Hugh Hefner's last wife, his widow. So the post Hugh Hefner era has always kind of interested me. I found Hugh Hefner's daughter, who actually took over his dynasty, Christy, really interesting. And she has taken some really principled, interesting stands about women's rights. So when I saw this, I thought, well, that's, first of all, Gloria Allred always interests me. She's been around a long time. Let me just say that. She's a fixture in California. And the Hefner, post-Hefner dynasty sort of has always interested me. So it caught my attention because they're talking about the Hugh Hefner Foundation. So I'm going to try and get through this as quickly as possible. I'm not going to play all of it, but let's listen to a little of it.
I'm going to read a statement, then Crystal will read a statement, and then we'll be happy to answer questions. We are here today, and we will give you copies of our statements as soon as we conclude. We are here today with our client, Crystal Hefner, to announce that today we filed regulatory complaints with both the Attorneys General of California and Illinois regarding the Hugh M. Hefner Foundation. Specifically, we are asking that the Attorneys General initiate a prompt and thorough investigation of the Hugh M. Hefner Foundation's actions with regard to the late Hugh Hefner's collection of approximately 3,000 personal scrapbooks containing thousands of nude images of women as well as Hefner's diary, containing highly personal information regarding his sexual exploits, including names of women he slept with, notes describing the sex acts that they performed, and in some instances, even information tracking women's menstrual cycles. It is our honor to represent Crystal Hefner, who is not only Hugh Hefner's widow, but she's also a brilliant, outspoken advocate for women's rights. Crystal did not consent to having her intimate images stored by and accessible to the foundation. And we believe that many of the other women and or girls depicted did not consent either. After she voiced her concerns yesterday, Crystal was unilaterally removed as the chief executive officer of the foundation. Crystal.
Okay, so Gloria goes on, Crystal gives a statement. I'll drop this link in our show notes in case you want to take a look at it. But that's really the meat of it. So after Hugh Hefner died, these 3,000 scrapbooks and personal journals were turned over to the Hugh M. Hefner Foundation. Now, over the period of years since Hefner died, I'm not even sure how long ago it was, but it's been quite a few years ago. I'm sure somebody in the chat will let me know. After that happened, his daughter, Christy, who I agree is a badass, and I've always found her really interesting, and his son were very involved in running the business and the corporation. And they were involved in this Hugh M. Hefner Foundation because the foundation was created with part of his estate. So they were very involved. Over the years, they have both left there and gotten out of being involved with the Hefner Foundation. And now we have Crystal, who was the CEO of the foundation. When she went to the foundation, apparently what happened was the foundation announced, we have all of these diaries and scrapbooks, photographs. Now, remember, this is the guy, the Playboy guy, for those of you who are too young to remember. I don't know whether there was any particular connection between Hugh Hefner and Epstein. They may have been generationally sort of enough far apart that there wasn't. But the foundation announced, we have all of these things, and we're going to digitize them. Now, we all know that there are a lot of organizations that are digitizing their archives, digitizing lots of things. But the question is, where are those digital images going to go? Because they are much more transmissible than the actual paper scrapbooks. So the scrapbooks, as they're described, of course, Hugh Hefner, the Playboy guy, there were pictures everywhere. And, for every picture that showed up in the magazine, there were thousands that didn't make the magazine. So, I mean, I'm sure that there are mountains of photographs. And we know that the Hefner's mansion was notorious for sex parties and a lot of gratuitous shagging, as they say. So when those scrapbooks were all in a physical form, then the access to them could be limited, right? You can limit access of somebody if you have a, if all you have is this physical book and the information's only contained here, then you can limit the access. But if you take that and you turn it into ones and zeros and you digitize it, now is much more difficult to control it because now you can have as many copies of it and as many distributions as you have email addresses. So I can understand why she is very concerned. And all of the other women who are potentially, no pun intended, exposed, their private lives being exposed by these documents, it's very concerning. I think that there's also the issue of consent. Hellis says, me saying gratuitous shagging wasn't on her bingo card. Well, honey, tonight's your night. So I think it's concerning because now this becomes a distributable product. And there are enough rich people out there who are willing to pay for it. And so I'm going to be following this because I'm fascinated by how our digital world is changing these things. We've seen that with Epstein, but we're also seeing it in other forms as well. So I'm going to keep following this one because I'm really interested in it. The other clip that I had pulled up, which if you will just have some patience with me, I hope I can find, is a clip from the Tara Baker murder trial. Now, Tara Baker was a young law student who was found murdered 25 years ago. And her case was finally solved by DNA that was found in her apartment. And so this person, whose name is Edric Faust, was convicted. Here it is. He actually was found guilty today. The verdict came in. But there has been some fireworks happening in the courtroom, specifically around his defense attorney. I know Melanie Little has been covering this trial, and I'm sure she had a lot to say about this particular exchange. But if you want to see a lawyer getting their butt handed to them, for lack of a better description, this is it.
Multiple times.
And thanks to Court TV for putting
As
this
court has
out.
Stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again.
So let me just talk a little bit about what a 412 motion is. So 412 is the rule in the evidence code that covers what we commonly call grape shield laws. Essentially, it means that you cannot bring the victim's sexual history in order to paint the victim as more susceptible to assault or more likely to be. You can't bring their reputation and their past sexual history in as a way to discredit the victim. And more and more courts have said the victim's history is not relevant to whether or not this crime was committed, whether it's rape or whether it's murder. In this case, it's a murder. So the judge is saying, so the typical process is, if you know as a defense attorney that you are wanting, for some reason, some permissible reason, legally permissible reason, to bring in the past history of the victim, You have to file a motion with the court. It's a pretrial evidentiary motion. You have to file that motion with the court pretrial, and you have to present to the court the reasons why that information needs to come in. And it has to be a reason that's permissible under the rules of evidence. So this judge is saying the defense kept getting into that, and the defense kept bringing it up in their closing argument. And the state was objecting to it. So the defense was bringing up the issue of the victim's reputation and somehow saying that the victim was responsible for the crime because she invited it or whatever. And the court cautioned this lawyer on several occasions that that was not appropriate to be brought in because he had not made a pretrial motion under Evidence Code Rule 412. And so we'll hear.
What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed.
So typically in these sorts of cases, those motions are evidentiary motions. They are filed in advance of trial because the judge wants to make rulings on what's going to come in pre-trial, doesn't want to be making those rulings as the trial is going along. But this judge says, I've even invited you to file a 412 motion now, even though it's not timely, even though I would be within my discretion to say, too late, so sorry. This judge has said, I invited you to file that motion.
Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you.
Now, I am here to tell you that you absolutely do not want to do that. When a judge is handing you your ass, the last thing you want to do is interrupt them. And to have a judge say to a lawyer, I'm talking now, whew, man, I understand that in the heat of the argument, in the heat of the moment, when you are standing there talking and you are on your feet and you are, all this stuff is running through your head and you're seeing your life flash before your eyes. It is tempting to jump in and try and justify what you've done. But it's very clear at this point that this judge is out, that this guy has gotten on her last nerve, that she is out of patience with this lawyer, and that she has been very, very clear that this was not going to, that it was not going to be allowed, and that he was way out of line. So keep listening.
You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is.
So this is a law that really is, I would say, almost sacrosanct within the law. I mean, prosecutors protect victims, defense attorneys who go after victims are really looked at as close to unethical. Going after a victim for no other reason than to paint them in a bad light to somehow suggest that because they had a sexual history that they somehow were asking for it. All of that is so unsavory and considered so unethical that the fact that this judge has to do that and has to say to this attorney, not only did you cross the line, but it's pretty clear that you were trying to circumvent the rules and get this information in front of the jury despite what is just common law, common knowledge, and common practice. It's pretty interesting. So let's see what she does.
It's not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you. As this court is.
So I'm wondering what y'all think of that. First of all, I can tell you that he's a public defender. And, public defenders get paid okay. Certainly, they don't get paid as much as prosecutors do. And they don't have, in a lot of areas, they don't have insurance. They don't get retirement perks. They don't get paid vacation. They're contractors that are paid as independent contractors. So that $1,000 is going to sting because he's got to write a check and he's got to be there at 9 o'clock in the morning to hand the check to the clerk of the court. That's going to hurt. So I found that just absolutely fascinating and just a little bit enjoyable. Because shame on him. Shame on him, particularly when he has been cautioned multiple times. And I didn't really like that smug look on his face afterwards. He was cautioned repeatedly not to get into that area questioning, that it was wholly inappropriate, and that if he had had any hope of addressing that area of questioning, he had to have brought it up in a motion. And to be cautioned that many times and to just sort of boldly march into your closing argument and start essentially defaming the victim, that's pretty objectionable. And I thought she kept her cool. I know of a lot of other judges that would not have been that contained when handing out that sanction. So, well, that is the last of the case roundup that I have tonight. And so I'm wondering what sort of questions you have for me or comments. Hi, Dawn Schaefer. Hey, Dawn, thank you so much for being with us earlier during Hella's live. I appreciated it. I had a blast with Hella and Dolly. I hope that they'll invite me back again. The first time I was on, of course, we were talking about Hidden and Lauren and all that stuff. And but this time we were talking about the Richens case, and I had a great time. And Dawn was in the chat. And Dawn and I also are knee replacement buddies because we had knee replacement done right about the same time. She's a little ahead of me. So she was very encouraging as I was gimping around and making best friends with my ice machine. So I'm doing better, still doing PT. I'm sure Dawn is too. Does it go on his permanent record to be sanctioned? Well, not really. So it's not, unless it is filed with the bar as an ethics violation. And it varies from state to state, but if there is an ethics violation, in general, that goes on your permanent record. So there's a difference. Hella, thank you so much. That was completely unnecessary. We are not a channel that that asks a lot for super chats. So it's very kind of you to send us something, but I appreciate it, but totally unnecessary. But thank you. So, will it go on as permanent record? In most states, if there is an ethics complaint, and it varies on the state. Now, my home state, Oregon, if you get an ethics complaint, it, it's up on the website that there is an open complaint. And we are so transparent that if you call the Oregon State Bar and say, I want to know what this complaint is, they will tell you. Even if the case is adjudicated and you're later found to have not been in violation of the ethics code, anybody who asks will know. We're that transparent. So it is in other states, they won't release that information until they adjudicate the case. And they won't tell you if the ethics violation is dismissed as groundless. So in 30 years, every lawyer gets an ethics complaint from a disgruntled client here or there. In 30 years, I never had a founded complaint, and I'm proud of that. But that's the norm. It should be the norm. Having an ethics complaint that's founded on your record, on your bar record, is a blemish on your license. So, but the court doesn't necessarily report that to the bar as an ethics violation. The court could, but I think she stung him enough by fining him. So she found him in contempt and entered a judgment against him for $1,000. So it won't go on his permanent record. But I can tell you, I don't know how big this jurisdiction is, but I guarantee that if it happened in my jurisdiction, everybody would know about it within about 10 minutes. Um, I had a colleague who was in the middle of trial, and there was I don't even remember what the case was, but it had to do with it was a criminal case, and it had to do with a, something heavy that was used as a, a weapon to assault somebody. And so when the the defense attorney was there and he was trying to say that this thing was too heavy to wield it and it was too unwieldy to wield it like a weapon, and he picked it up, and when he picked it up off the table, he dropped it, and it tore a big hole in the carpet. And the courthouse had just gone through kind of a recent remodel, and the carpet was new. And the judge was was one of those judges that their courtroom was like their living room. They had really owned it. And so the lawyer was really apologetic. "Oh my gosh, Your Honor, I'm so sorry. I had no intention of dropping this. Just clumsy." And the judge sent the jury out. And when the jury was gone, he said, "I will expect that you're going to reimburse the court and have that fixed." And he did. He called the carpet company who had laid the carpet and asked them to come and patch the carpet. And it cost him, I don't know, $1,000 or so to replace that piece of the carpet. And that was really kind of an accident. So, it doesn't surprise me at all that this judge just said, "You've been told enough times, and, now I'm lowering the boom." And as I say, I know, of a lot of other judges that would not have been so, composed when they, lowered the boom. So, um, if he doesn't pay, does he get jail time? It's possible. He could be held in contempt of the court's order to pay it. If he were smart, he'd be down there at 8:59 with his checkbook, to make sure it gets paid. Because if he doesn't pay it, then it does become a potential ethics problem, because I guarantee you the judge is going to be dropping a dime on the ethics board if he doesn't pay it. Yeah. So, what other questions have we got for me tonight? Gosh, to quote Kathy from Gossip, Rumor, and Innuendo, I done talked my throat dry after a couple hours with Hella. Hi, Grizzly Bear Kelly D. You were also in Hella's chat earlier. Where was the guy that tried to insert himself in the case? The judge brought him to the courtroom and then fined him. That was Chad Daybell's trial. Yeah, that was so sad. He was a lawyer from the local area around Boise. He was an older guy. And I understood what he was trying to do. But I think just sort of reading between the lines that he was a little outraged by the fact that close to Chad Daybell's trial, Chad Daybell's lawyer asked to withdraw, saying that he wasn't being paid anymore. It was more about the fact that he didn't have the resources that he needed to continue to prosecute the case. He was prosecuting the case as one person. He didn't have co-counsel because he couldn't get co-counsel. He didn't. He had limited access to an investigator, and so he was really, dancing as fast as he could and doing his best with the resources that he had. So he went to the judge and he said, "Judge, I would like to withdraw from the case because I think my client is owed that. He's owed competent representation, and I feel like I'm spread so thin. I don't have all this assistance." And so the judge said, we're on the eve of trial, and this trial's been put over for almost 2 years. I'm really hesitant to allow that. And they kind of went round and round about the fact that this was a death penalty case and that John Pryor wasn't death penalty qualified. And I mean, it was kind of a mess. What the rules in Idaho said was that if you retain a lawyer, you're responsible to make sure that the lawyer is qualified to represent you in the case that you're hiring them for. So Chad Daybell was able to hire John Pryor, even though he was not state certified in death penalty litigation. And the state has these specific guidelines, these things that you have to meet to qualify. You have to have certain qualifications to be able to defend a death penalty case. If you're appointed by the state can control that. So there was this weird tension because he was retained, but if he couldn't be appointed because he wasn't death penalty qualified, and he tried to get a lawyer who could be appointed and was death penalty qualified to come in. That didn't work. So he was sort of feeling like he was between a rock and a hard place. Now, quite honestly, he should have done this way before. To do it on the eve of trial, I understood completely why the judge was like, this is kind of a non-starter. So ultimately, he told John Pryor, I'm not going to relieve you of the case. And John Pryor, you're going to be working for free until you're done with the trial. And that didn't set well with this other guy who was a very experienced public defender, older man, because he felt like Chad Daybell was being done a disservice. Like he did not have proper representation because he didn't have a death penalty qualified attorney. That may be right, and it may certainly be being addressed in the Supreme Court on Chad's appeal, because death penalties, it's an automatic appeal. But to read between the lines, I think what happened was he was very outraged. And I think that he also may have had a few adult beverages while he was being outraged. And so he went down to his office and he submitted motions asking to be joined in the case for the purpose of advocating for Chad Daybell that he get death penalty qualified counsel. The judge wasn't having it. And the judge, I can see both sides of it. I mean, I felt a little sorry for this lawyer because he really was trying to do something for the right reasons, but I think he went about it completely the wrong way. And at that point, the judge, who was the judge from Rexburg, from East Idaho, who was sitting on the case in Boise, who had kind of a hair trigger anyway, he wasn't having it. And so he let the guy have it with both barrels. And that included him paying for all of the attorney fees for the prosecutor to answer the guy's motions. And it was a mess. And I think it was really unfortunate. I think he had good intentions. I think he was a little had a little liquid courage in him when he decided to go to bat for Chad Daybell, and it backfired on him. So it was kind of sad, and he was kind of a sad older guy. And maybe wasn't exercising the best judgment at the moment. So what other questions do you have for me? Oh, grizzly bear, it's my beaver cup tonight. You missed the duck cup. I will tell you that my duck daughter, when she comes over, she will only use the duck cup that you sent me. Grizzly bear Kelly. For those of you who are not up on Oregon college athletics, the two primary colleges are Oregon State, which is the ag college, and University of Oregon. Oregon State are the Beavers, and University of Oregon are the Ducks. And there has been a 150-year rivalry between these two teams. So my husband is a dyed-in-the-wool Oregon State Beaver. My daughter went to University of Oregon, met her husband there, and so they are absolutely avid Ducks. And for many years, I said, I didn't go to either school. I don't have a dog in the fight. I went to a private Catholic college followed by a private school for law school. So I don't have a dog in the fight. But then I went and got a master's in creative writing before I retired. And that was through Oregon State's Central Oregon campus. So I'm now a Beaver. So we have a family rivalry. I have adorable pictures, which I'll one day I'll pull up of my husband and my daughter all dressed in their gear back to back at what used to be called the annual rivalry game between the two teams used to be called the Civil War. And so the Oregon State Beavers are orange and black. The Ducks are yellow and green. And so they were all decked out in their respective school regalia, giving each other the stink eye. And that is a common occurrence in our house. So Grizzly sent me a duck cup, which I alternate using. And but I can tell you that my daughter, it's the first thing she goes for in the cupboard when she comes to visit. So hi, she opines. Are aggravators brought in during or after verdicts? This is a good question, and it actually one of the most annoying answers from a lawyer is it depends. So in a case other than a capital case, the aggravators need to be proven before the judge can consider them in sentencing. So in other than a capital case, the judge imposes sentence. So for example, let's just say, to make it simple, that we're dealing with a robbery case. Robbery is forcibly taking someone's property. So we have a robbery case. The aggravator is if a firearm is used. So it's important for the prosecution at the very beginning of the case to charge that with the aggravators, not just charge a robbery, but charge a robbery with the use of a firearm. Because when they get to trial, they'll need to prove that a firearm was used in the commission of the crime, and that elevates the sentence that the judge can impose. So in all but capital cases, that's the way it's done. In a capital case, the aggravators go to whether or not the death penalty can be imposed. So for example, in the Daybell trial, we have a guilt and an innocence phase, and we say that's a bifurcated trial. But within the penalty phase, there also is something of a bifurcation, because the jury first has to determine that there were sufficient aggravating factors, that the state proved the aggravating factors that would allow them to ask for the death penalty. So during the guilt or innocence phase, they had to introduce the evidence to prove the aggravating factors. Then during the penalty phase, the prosecution would have to put on sufficient evidence to show that those aggravators had been proven. If the jury finds that the aggravators have been proven, that yes, it is appropriate to be seeking the death penalty, then the next question for the jury is, has the defense provided any evidence that would mitigate the death penalty, that would cause us to spare this person's life in spite of the fact that the aggravators have been proven? I hope that answered the question. Sometimes I get so lost in the answer, I'm like, does that make sense? Did I just answer the question? So if I didn't, let me know. The aggravators really, where they really matter is when the initial charging is done, because the prosecutor wants to make sure that those aggravators are charged so they can be proven at trial. If they're not charged, then the prosecution can't bring them in later and they can't factor into sentencing. So, what else you got for me tonight? Hello, this normal Idaho mom. Any thoughts about Lori Daybell's appeal as of late? We haven't heard a lot. We haven't heard a lot about the Idaho appeals. I want to remind you that appeals move slowly. Here's an example. Recently, the appeal has been underway in the Richard Allen case, the Delphi murders, since his conviction, which was a year ago. One of the first things that had to happen was a transcript of his trial had to be created, a written transcript. And that's a horrendous job. And you have a trial that takes 6 weeks. It takes months just to get the transcript done and certified. So the appeal process appeal timelines can't start to run until that transcript is finished. Then they have the defense or the person appealing has so much time to submit their opening brief. The respondent then has so much time to answer that brief. So in Richard Allen's case, the defense has filed their appeal. They asked for leave to file longer, more pages than the typical appeal because of the issues. They were granted that within reason. There are page limits on appeals, so you have to be able to fit your argument and all of your authority within those pages. And then they sat back to wait. Well, the state now has so long to answer. The state just, I think today or yesterday, filed a motion for yet another, the second extension of time on them filing their answering brief. So that draws everything out. There can be rebuttal and surrebuttal if the rules of that state allow that. And once all of those briefs are filed, then the court will set oral arguments, and that can take months because all of that information that is presented to the court, including those voluminous transcripts, are all submitted to the appellate court, and they have to read it all and prepare and before they can make a decision. And then they schedule oral arguments. So that could be months out. They hear oral arguments from both sides. They're very brief arguments. If you've seen Supreme Court arguments, recently we saw a Supreme Court argument in the Adelson case, and sometimes they have as little as 20 minutes to present their arguments. So once they've presented their arguments, then the court takes it under advisement, and it could be more months before they actually write an opinion. So the appeals process is not fast. Now, in Lori Vallow's case, we know that she's filed appeals in the Idaho cases, the murder cases for Tylee JJ and Tammy Daybell. I don't know where that's at, but I know that they've filed the briefs. I don't know where in the process that is. I'm going to make a note and see if I can look that up. Hang on here a minute. I can't walk and chew gum at the same time. Vallow appeal status. So I'll look into that one. I know that she intends to file briefs, file appeals in both the Charles Vallow and Brandon Boudreaux cases in Arizona. As far as I know, they're still working on trial transcripts for those cases. And it wouldn't surprise me if it takes a while before those are done. Even those were much shorter trials. But it took months, if not a full year, to get the transcripts for the Idaho cases because that was a 6-week plus trial. And what happens when they begin a trial transcript is a transcriptionist. Now, these people it's not just anybody. They are certified by the court to transcribe because they have to be trained and they have to be accurate. And so the first person sits down with the recordings and begins transcribing what's going on. But in order to ensure the accuracy, a second person is going to be listening to that recording and reading along with the transcript and noting anywhere there's a mistake or a typo. And so it is a very labor-intensive process. And when it's all done, those two people then certify that this transcript is an accurate recording of the trial. So it's a really, it takes a lot of work, and that's why appeals take so long, because sometimes it can be up to a full year before the transcript's ready. And it's not fair to say, tick, 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 the clock's ticking, let's get your briefs in when the transcripts aren't done. So that's what happens. Other questions? Hey, Don. If financial problems are brought up as a motive for Corey Richens, like in the Murdaugh trial, will it impact the financial crimes trial? How much can be shared in the murder trial? Good question. This was a point of contention in the Murdaugh case, and the defense sought to keep a lot of that out. And there is this kind of very subjective test, which says that the evidence cannot be more prejudicial than probative. And that is a real value judgment that is left up to judges. And the judge in the Murdaugh case said it was important to bring it in as the motive for the crime. Whether it was necessary to bring it in such detail, I think is a question for the appeals. I think they will bring in enough to flesh out the motive. So here's the thing about, we hear over and over again in criminal trials, the state doesn't have to prove motive. And that's true. There's nothing in the state statute that says you have to prove motive. You have to prove state of mind, whether it was intentional, knowingly, recklessly, any of those mens rea or mental states. But they don't have to prove motive. However, juries are human, and humans want to make sense out of things. And juries want to know why, even though the state's not required to prove that, and the jury isn't required to consider it. Sometimes juries just can't get past the why did this happen? And so that was the case, that was the part of the Murdaugh trial that the prosecution was really intent on getting in, because their theory of the case was that Murdaugh committed the murders to take away attention from all these other financial things he was doing and to get sympathy. He saw it worked when his father died, and he was trying to buy time until he could figure out how to, I don't know what, he was trying to figure out how to play the shell game and move stuff around so that it wouldn't look so bad. So I think probably in the Richens case, we won't see quite as much of that, but I do think that they are going to have to put up some of that to show the motive and to show that she was counting on getting the payoff from Eric's estate and from his life insurance, not knowing, sounds like the Vallow case, that Eric had changed his will and changed beneficiaries and all of those things. So I think they have to put some in. Not sure that they really needed to put as much in as they did in the Murdaugh case. And I think it could be an appellate issue. Is the appeals court going to overturn the discretion of the trial court? Unlikely. Trial courts are given wide discretion. And I think that often appeals courts are going to defer to the trial court, who was there and who saw the demeanor of people and all of those things, and likely not going to overturn it based on that judge's determination and his judgment. There are other places where you can talk about there being actual error, but abuse of discretion is a really hard standard to overcome, because the presumption is that the judge who heard the case had the opportunity to look at all the facts and all of the people and body language and a number of intangible things in deciding whether or not to let that in. So good question. Anybody have one last question? Otherwise, we'll wrap it up. Thanks so much for being here. I want to say thanks again to all of you who followed me over from Hella and Dolly. I appreciate that so much. I appreciated being with them tonight. I had a blast, and I look forward to getting together with them again. I always want to say thank you so much, Jen, our fabulous moderator who keeps everybody on track, keeps me on track. and posts all kinds of interesting things in the chat and information. I will drop the links to the 2 videos I showed tonight in the show notes, so you can go look at those if you want a deeper dive. I didn't show the video with Gloria Allred and the Playboy stuff is about 20 minutes long, so there's more of it, but that's the meat of it. And as always, if you have questions, drop them in the chat. If you don't feel like they're a question you want to make public, drop it to me in email. My IT guy is still working on getting everything consolidated and into a new email. So for now, the Lori Vallow email is still working. So let me know if you have comments, questions, other cases you would like me to cover. I do still have notes of things that we want to get to. Um, I do still want to talk about why the Pacific Northwest had so many serial killers. That is a great question, and I have been reading a book that answers that question, or at least presents a theory that I found really, really interesting. So there's still some things to talk about, but isn't there always something new to talk about? I'm sure by next time we meet, we'll be talking about wrapping up the Dee Warner case, and we'll be heavily into Corey Richens. So thank you again for joining us. I love our chats. I love our community, and I appreciate you all. So have a great week, and we will see you next week for more true crime. Good night.